for that. My name is Wu. I'm a professor at Harvard Law School, and it's my pleasure to be moderating today's panel. We have 4 experts here. I will just quickly introduce them, but they are seated in the order of the names with one important distinction here. So to my immediate right is Pieter Van Vaerenbergh. To his right is Kun Hui. Apurva has unfortunately not able to be with us, to join us today. Then seated to Kun's left, to your right, as you all see, is Theófilo Aquino. And then we have in addition, which is Geraldo Vidigal, who is, I think, well known to all of you. So even though he's not listed there, I trust many of you know who is seated here before you. I know that some of these panels have focused on papers which were submitted for the conference itself. We are not going to do that today because this topic, one of subsidies, is one that we've heard throughout the last 2 days is one of critical importance, and there is so much expertise in this room that we are going to actually try to do what the title of this topic is, which is really to reimagine subsidies control. So what I'm going to do instead is ask each of our speakers to just very quickly sort of highlight the views and key points that come out from their scholarship. But I do want to encourage all of you after the event, if you wish to follow up, they have either articles or in some cases pending books, dissertations, and so forth on this topic. And so please do exchange cards, have emails, and I'm sure all of our panelists would be more than happy to provide you with the full scope of what they'll be talking about today. So with that, I just want to welcome all of you. And I think this topic really doesn't require much of an introduction. Certainly the topic of subsidies is one which has continuously confounded the global trading system, going back to the GATT days, the Tokyo Round Code, but is one which we've seen come up repeatedly over the course of the last quarter century, as we've seen new economic structures come about for which the original agreement on subsidies countervailing measures did not necessarily take account of, as we've seen the reemergence of industrial policy, as we've seen jurisprudence be made, some of which has been made by people sitting in this room, that has then provoked reactions from governments and former negotiators as being contrary to what the intent was. And now, as we've discussed, we've seen the 2 key areas, both fragmentation of supply chains and the energy renewables transition rely upon subsidies to help facilitate that. So needless to say, right, this topic is one that imagines a lot of new thinking here, and I hope in the next 90 minutes or so we'll be able to provide that. So I'm going to kick off today's panel with just a very basic question to set the scene here. Why is it that the existing subsidies rules are not working, in each of your opinion? What has come forth in your research, and why is reimagining required? So Pieter, let me start with you, since your work focuses especially on the environment and on the sustainable transition right now. What's not working in the ASCM with regards to the climate crisis and the energy transition ahead of us?
Thanks, Mark. Indeed, my angle for this initial intervention will be the environmental angle. And before that, actually, I want to say thank you to be here. It's an absolute honor, and also a bit nerve-wracking to be alongside all these experts, some of which indeed have made the discipline and have been my teachers and my sources until now. But nonetheless, I'm glad to talk or to introduce here the failure or the shortcomings of the SCM rules from the environmental angle, and I would like to split that in 2 parts to start off. The first part will be the subsidies part itself, and the second part, the countervailing measures part. On the subsidies parts, of course, it's the discussion delves around the environmental subsidies, and although there was a small environmental exception in the SCM agreement, of non-actionable subsidies for an environmental purpose. For now, environmental subsidies are treated just like any other subsidy as a prohibited or actionable subsidy, and can therefore be part of investigations in other WTO members. The SCM agreement and these investigations are more focused on the potential trade effects of these subsidies and not as much on the potential positive externalities, positive environmental externalities that these subsidies are warranted. And that's, in my view, one of the first points to mention on the SCM agreement. On the countervailing measures side, it's a much less discussed topic and one that I have been looking into. Many people don't consider that countervailing measures and trade remedies in general are suitable instruments to exert any other policy objectives than the clearly economic ones, because the rules are too detailed, too technical, too specific for other policies to play any role. That's translated in a very competitive injury concept, stern calculation methods, etc. The only part, perhaps, where the environment can kick in would be the public interest test, where investigative authorities can take account of the broader context. But as we know, not all WTO members will apply that test. So for this first small introduction, to conclude is basically that the SCM rules, they don't have any environmental angle on paper. It has to be written in or read in, and that's where I'm going to keep it for now.
Okay, thank you. And the other major topic here is, of course, state-owned enterprises, but it's more than just state-owned enterprises. As I've written about in my own work, right? It's also particular to China and the China Inc. structure, and also the organization of the political economy beyond state-owned enterprises. But let's start with the element of state-owned enterprises, which Theófilo is, it's a big element of your work. So, Theo, why don't the existing rules work with regards to SOEs? Because certainly 1994, we knew about SOEs. They've been a feature since the Tokyo Round Code. So what's not working about the rules with regards to SOEs?
Yeah, thank you, Mark. Thank you for everyone who showed up. Well, my contribution here is based on my ongoing PhD dissertation, which is due to February. So it's going to be great to listen to the input which you all might have on this work. I'm going through some a bit of a sort of hard phase now to finish the work. And so my short answer to your question, Mark, and which is one of the biggest questions of my work, is there is no agreement on what counts as an SOE. The dispute here is basically what is an SOE, right? There was some kind of agreement, I guess, like 20, 30 years ago, what would count as an SOE in trade and investment regulation. And then for one particular reason, which is China, which we'll address, I guess, in the next round of this panel, this agreement has fallen apart. So my question here is what counts as an SOE, and there is no agreement on what counts as an SOE. So it's not just which measures justify retaliations or some kind of compensation, but actually which actions taken by whom, right? By which actor. And so first I would delimitate here my first contribution. There was some sort of agreement on what I'm calling here the government authority approach. So there was some definitional common ground here based on this idea of government authority, which was enshrined in the WTO precedent and WTO law, and also in the 1990s, 2000 regional and bilateral agreements, which basically said that we'll count as an SOE for subsidies or other kind of primary rules scope, whatever economic agent which acts within or embodied with government authority. And this approach was confronted with practical difficulties. So to mention a few, conceptual clarity. So authority per se it wasn't clear what was meant by authority. And other practical difficulties such as transparency requirements. So like, how are you going to define when an economic agent is acting with governmental authority? So But I would point out that these questions did not matter so much until China became a relevant economic actor. So both after China extended to the WTO, and also I would point out 2011 when China consolidated itself as a major source of foreign direct investment. I guess those are the milestones where these practical difficulties with the government authority approach got more serious. And so then there were proposed solutions, which in itself have their own difficulties, such as the idea of ownership and control, some kind of functional approach as to the kind of activity that the enterprise assumes. And I guess we can go a little bit deeper in these approaches in the next rounds.
Quinn, let me invite you to elaborate further, since your research focuses particularly on China. If we look at authority, if we look at function, it's very complicated. So what should this audience understand about this?
Thank you, Mark. Thank you, Mark. Thanks everyone for coming. My PhD thesis examined the relationship between China and the Chinese state-owned enterprises under the law of sovereign immunity. So based on that research today, based on your early question today, I want to zoom in on a particular question on the WTO SCM agreement regarding the definition of public body. I think it's still a controversial issue under the WTO about to what extent Chinese state-owned enterprises, for example, can be considered as part of the state, which would trigger the responsibility of the state of China under the WTO rules, for example. And as Theo earlier mentioned, there are different approaches when it comes to the interpretation of whether an SOE is part of the state or not. For example, even under the WTO jurisprudence, under the law of sovereign immunity. And here I want to briefly mention two WTO cases between China and the United States, one from the 2011 and one from 2019 about the US anti-dumping and countervailing measures initiated by China. So in the first case, the appellate body kind of rejected the US ownership approach of treating this SOE as part of the state. But in the latter case, I think the appellate body elaborate upon the authority approach of to what extent, for example, a Chinese SOE should be looked at its individual action of a specific transaction, or the SOE should be reviewed as a whole in the Chinese political economy context. I think the appellate body in the end declared that we don't need to look at a specific transaction of an SOE, but rather we need to look at the SOE as a body of entities or a collective entities. So I'm just gonna stop here. Thank you.
And Paulo, if I can invite you to zoom out, right? So we've looked at this with regards to the two key issues, but there's also this unending question over what's the object and purpose of this agreement as a whole. And this is one of the defining elements here that remains contentious. So
thanks for the organization for inviting me to Mark. I ended up involuntarily composing an all-male panel, and I will just like the names for that. So this is interesting because since I've been asked to talk about this, I've been thinking there are two types of WTO rules, more or less, right? And I think because this is Amy, and she doesn't entirely agree, but there are some rules that are purposive in a way that there's a higher object and purpose to them, and there are others that are just a deal, right? If you think of the anti-dumping agreement or tariff schedules, these are just a deal, and there's no particular reason why a tariff is 25 or 10%. It's just that that's what you negotiate. Whereas for other rules, you can have a justifiable reason to deviate from them, and determining where the line is between the justifiable and the justifiable is what ends up panel and the appellate body end up doing. Now, the subsidies agreement looks a lot like the second type of rule, right? So it's a rule not to subsidize or not to grant self-preferential subsidies. There's no purposive exception there. And that the fact that people become uncomfortable with this is clear. And of course, as most of you will know, of course, there's the Canada renewable energy case, unfortunately better known as kind of the fit to the experts, when the other name is much nicer. And that's the upper body that what a lot of people found very questionable, which was to create this sort of weird exception for when a country is making a new market, by which seems that they meant when a country is trying to address a market failure or address a situation where a member wants to subsidize in order to avoid a negative externality. Now, there's no exception in the subsidies agreement for this, therefore they sort of came up with this weird theory of making markets. Of course, this is what's weirder about this decision is that this ruling was immaterial to the final outcome, because what matters is not whether there's subsidy or not, but whether the subsidy is self-preferential. So when we think of reforming the subsidies agreement, I think that's the main question, at least for the environmental part, not necessarily for the part on the China issue. And of course, the experts are here on this. It's to allow members a degree of freedom to grant some certain self-preferential subsidies if by doing this, if this is the price that you need to pay in order for them to do things like protect the environment and things like that, or in particular the environment. Now, is there room for this? I suppose there could be. You could have some sort of, and Frank Garcia spoke about Adam Smith today, and you could have this idea, that this Smithian idea that by the private vices of members, they somehow they can contribute to a public good, and this is something that has been explored by people like Tim Meyer, for example. And I think that's the, let's say, the most the clearest example of where you could go with this. Now, where do you draw the line, right? How far would a self-preferential green trade, green subsidy exception go? And I sense that maybe we could get something from this out of this EU-Mercosur agreement. It's going to be negotiated over the next 2 weeks. And I feel that this could be one way, right? So as long as you meet certain requirements, and as long as the subsidy, the self-preferential aspect contributes to addressing a broader market failure, that the countries would be able, or members would be able to give some degree of self-preferential subsidies. And I'll stop here.
Okay. So I think we've heard a lot about what's not working. Anything else? Anyone on the panel want to add or react to what's been said so far?
I wanted to add maybe one more aspect for discussion, and that's the topic of transparency on subsidies. I think it's also a big debate and a big problem currently, because there's a clear obligation for all WTO members to make notifications and to be transparent about their industrial subsidies, but year after year after year, as far as my short career shows, the majority or a large part of the WTO members, they fail to notify either completely, partially, or in time. There's a lot of problems, and that's problematic because it will impede other WTO members to exercise their rights under the SIEM agreement to investigate those subsidies, to potentially initiate cases in front of the dispute settlement body, or to carry out domestic investigations, anti-subsidy investigations in their countries. So that's maybe an addition to the shortcomings of the current situation.
Anything else anyone wants to add? Okay, so let me pivot us then a little bit into the reimagining things, right, now that we've set the scene. There's been no shortage of discussions in Geneva. There's been no shortage of proposals to the SCM committee. So for those of you who do research on this, right, you've got a lot you can work with if you want to do empirical data. And there has been progress. It's not to say there's been no updating of the rules whatsoever. One area where we did see conclusion of the new agreement is with regards to fishery subsidies. So let me start and ask Peter just to weigh in on what can we learn from that experience in terms of what could still work within the WTO, the multilateral type of structure.
Yes, the fisheries subsidies agreement, it has not been discussed a lot in the panels that I attended, but it has been mentioned in one where the discussion was, is this an evolution or a revolution in WTO law? I myself see more of the historical momentum in it, because not only because it was a successful conclusion of a new WTO agreement, but also because of this explicit link to environmental concerns and to this explicit call in the SDGs for the WTO to take action against fisheries subsidies. And for those reasons, I do believe that it is rather a revolution than an evolution. On the contents, I must admit, indeed, the new agreement creates new categories of prohibited subsidies, which is already a mechanism that exists and is thus in line with the current SCM agreement. And one point that I would like to carry out or to plug out there is the fact that unilateral remedies, so countervailing duties, are not part of the final agreement. So it's the fisheries subsidies agreement does not foresee a possibility for WTO members to impose countervailing duties in the framework of the new agreement. But that would have been a very, very interesting question or a very interesting development to see, because the remedies have to be linked to the object and the purpose of the agreement, which is in this case not so much competitive concerns or trade-related concerns, but really this environmental angle. And therefore, the concept of injury, the concept of harm, the concept of the remedy and the calculations would have to reimagined and rethought in light of that. So that's maybe something that if anybody has any thoughts on that or wants to engage in that, would be very interesting to discuss in this room. And another point on the fisheries subsidies agreement is, of course, if this model or if this victory can now be reproduced for other types of environmentally harmful subsidies. So that's going to be, I think the first target would be the fossil fuel subsidies, on which a lot of work is already being done. But it will be interesting to see if this momentum will be to lead to more innovations at the WTO.
And so let's take that question. Any of you optimistic if you were placing bets that within the next 7 years, by 2030, we'll see anything else?
So you're setting deadlines as well.
Along the lines of, well, I mean, we can say 2035 if you want to be even more, but I think 2030 is a reasonable time frame in the next 7 years. Right, so we're not talking short by MC13 or MC14, right? Where you could see this type of revolutionary rethinking of object and purpose leading to a new set of rules. Any other areas you focus on for the negotiations?
Yeah, may I pick up on that? Yeah, so just to clarify a point I made earlier. So in my work, I'm looking not specifically on WTO, but I'm looking to bilateral and regional agreements signed by the EU, the USA, and Japan. And I'm trying to track down what kind of development rules on SOEs, and specifically how these countries have developed their definition of SOEs on those kind of agreements. And what I'm actually finding is that there is somehow a convergence already happening, and a new set of rules rising within this specific club of the USA, the EU, and Japan. What I would say is an interesting fact that I found is that the USA has somehow defined and regulated SOEs at least since 1995 in the BIT with Honduras. And it used a very specific criteria of ownership, just ownership. So it said, okay, it's going to count as an SOE, whatever enterprise which the government controls through ownership interests. And it specifically discarded mere regulatory control. So in the presidential messages to the Congress, specifying the interpretation that it was meant to those agreements. For instance, in the 1997 BIT with Jordan, or in the 1998 BIT with Mozambique, it was specifically discarded any kind of regulatory control. And then China comes up in 2001, and you see a development in Japan's practice. In 2005, Japan signs the economic partnership with Malaysia. And it, for the first time, brings in the idea not only of ownership, but also the idea of control. So you have a correlation here with the appearance of China and the attempt to broaden the control through ownership through some sort of other means of control. And then in 2014, the EU converges to this practice in the Ukraine Association Agreement, and then you see the USA in the TPP and the USMCA, and now you have some kind of convergence in the idea of 50% of shares, 50% of voting rights, some kind of minority control, or any other means of board member appointment. So there is, I would say, an evidence, and there is evidence of an argument to be made here that somehow the rise of China correlates to a convergence here between the EU, the USA, and Japan on how to define SOEs in these agreements, and this should be relevant to what counts as a target in the subsidies or transparency or regulation or any other kind of primary rule here. So I don't know if the idea of what kind of better regulation. I don't know if better is the idea we should work with, or of possible regulation in this multipolar world, which has a clear attempt of answering to China. I don't know. That would be my contribution.
So I think this is a nice segue into the next part of this. But before I move on, I just want to check. Anyone want to be an optimist here and say, hey, we might actually see not club-based, right, which is what Theófilo is talking about, but actually true WTO deliverable, either through a plurilateral or through a GSI initiative, or actually through a ministerial declaration of anything on reimagined subsidies rules in the next,
well, I mean,
in this decade.
This is a generic comment, I guess, but it's a bit of what is it, the night is darkest just before dawn situation. If you think about how the Uruguay round came to be, right? We had more or less the same situation going on in the 80s with more or less a similar array of measures. Of course, let's say we now think that the US-China geopolitical dispute is much more significant than US-Japan ever was or could be, but that was not the feeling in the 80s, right? And so that eventually gave rise to the WTO. There could be something like that, in fact.
So when I was studying trade law, and I think when many of you were studying trade law, right, we heard this theme of building block, stumbling block. No one's talking about building blocks today, right? It's all about club-based approach, fragmentation, and so forth. So I think the optimism, right, that even a convergence within a club is serving as a building block, that geopolitics is quite different these days, right? And so a lot of the action that we're seeing is either unilateral or it's within these like-minded clubs. And it's not just within the advanced economies, as Theófilo talked about, but also you look at the actions being taken by developing countries and the models that are then being exported and being transposed and so forth. We're also seeing this amongst developing countries. And we see this in China's trade agreements, but we also see this in many of the large trade agreements that are being concluded by other developing countries as well. So the question that I just want to pose is, much of your research focuses on these types of agreements, not multilateral, but bilateral, club-based, and so on and so forth. And this is where the play in the action is right now in terms of reimagining subsidies controls. So what should this audience learn from your research? What are some of the key insights that come about from all that? And normative question I just want to ask is to say, if this is no longer serving as a building block, is the development of these types of rules still a good thing? Or is it, will we be better off with not the creation of these types of alternative approaches? So maybe Peter, let me start with you. We are seeing a lot of action on this with regards to environmental subsidies, environmental issues, particularly within the US and EU, but also elsewhere. So what do you think?
Indeed, a lot of action, a lot of new various players on the global market have been emerging in the last months and years, to be able to advance and to be able to keep the ball rolling, let's say, and to be able to catch up on the new developments. I think, and one example that I could, or a couple of examples that I could highlight here is the effects that have been discussed in several panels, and the effects that will be expected, for instance, from the initiatives such as CBAM or even the GASA agreement, that they might be controversial, they might be creating a lot of open questions, but still they are a start, and they are definitely to be followed and definitely to be joined in by other parties. I think I heard this a couple of times in the panels before, that once started, this will be joined by other people, by other companies, by other countries. Sorry. So I feel that even though it has a lot of obstacles to overcome, it might be beneficial for the world community that certain members start off and then others can join in at their own pace.
Thanks, Mark. I think I'm going to ask you a question, answer your questions in two parts. First, I think multilateral engagement in some sectors is crucial. For example, in the agriculture sector, if only a few countries agree on subsidies issue, I think it will give other countries a free lift, which would not work. So I think since you are around, there has been no progress on this issue. I think this is not only an inspirational for member states, but I think it's also necessary for states to talk about it, particularly when China does not want to agree to more concession unless the US and EU has do the same. So I think that's my first part. So I think more negotiation is important. And the second part is about, do we want more rules or more at a club level or unilateral level? For example, on the SOE, on the rules of SOEs. So for example, some scholars, including you, have expressed whether the current WTO rules are sufficient to regulate China's state capitalism, including Chinese SOEs. And also other scholars have recently expressed that actually we should look at the WTO rules, including its China's accession agreement. I think Professor Gao in his recent book, and Peter, you've also made that argument. I think at this geopolitical context, maybe while creating some more rules, maybe we would think how we can use the existing rules and the existing system to solve the problems.
So I don't know if I'm going to be too pessimistic here. I don't want to break the chain of optimism, but my take would be, and this is a hypothesis of mine right now, that when we're talking about like rules on SOEs and whatever other rules of conduct or requirements that comes with it, right now we're talking about guaranteeing and assuring market access. So we're not really talking about creating some kind of multipolar, multilateral efficient system. Rudins has this article, Interface 2.0, in the Journal of International Economic Law, like 3 years ago, so in which she argues that somehow you should come up with a kind of type of activity criteria to create some kind of bridge or interface mechanisms between different economic systems, which could somehow work to provide some workable criteria, right? So to create a common ground on this regulation. But I would bring up two evidence to highlight how I believe it's all about guaranteeing market access and protecting itself from competition, I guess. So if you look at the geographical distribution of which countries, USA, Japan, and the EU signed agreements in which there are specific rules on SOEs, the USA, more than 70% of its agreements are signed with Latin America. Even after China rose, most of the rules on SOEs in USA, bilateral and regional agreements are signed with Latin American countries. The EU, it has an equal share of Eastern Europe countries and Eastern Asia countries. I would say that perhaps these rules with Eastern Asia countries could be explained because the EU has only began to include this kind of express criteria in its agreements after 2011, when China was already a problem to be dealt with in the European perspective. So I would say that might explain it. And Japan, if you look at the geographical distribution, most of these rules are signed with Pacific region countries, so either from Eastern Asia or Latin America. So I believe this is a very good evidence to show that these countries are trying to somehow protect their respective regions of influence and their respective markets. Another evidence I would quote, and this is very brief, but I haven't seen so much. Perhaps I need to look into a little bit more. But the Article 22.7 in the USMCA agreement on adverse effects. I would read that as close a confession as it gets from we don't want any kind of competition here when it comes to subsidies or somehow some form of non-commercial assistance to state-owned enterprises. So yeah, I'm not very optimistic of any kind of multilateral solution unless this multilateral solution could somehow protect these countries from any kind of competition.
On something entirely different. So I think that just to think through a bit, what kind of change this agreement has to go through. I think one of the main issues, and again, how you would frame this legally is still a challenge for all of us, but that all of these rules were negotiated having in mind the realities of the early 1990s, right? And the realities of the early 1990s were very much still those under which the GATT was negotiated, in the sense that countries or then WTO members later on negotiated on the basis of two assumptions. One, that they were negotiating with each other as entities that regulate their own market, and so therefore each country regulates their own market, and therefore they compete in this sort of international market. And then the idea that there is a divide, and again, this has never been, of course, perfect, but there is a divide between the public and the private that you can use. There is a dividing line, right, in which there is a space such as the market where companies can compete, and they compete as companies from different countries. And therefore, Brazil protects Brazilian companies, Colombia protects Colombian companies, and then they negotiate on the basis of their interests. Now, this has changed in two ways, and I think I'll use the new EU unilateral measures regarding subsidies to try to illustrate the ways in which this has now changed significantly. The first is the foreign subsidies regulation. So now the EU has decided that if a third country, now so not an EU member state, offers subsidies to a company to either buy a company in the EU or be part of a public bidding, that the EU can counter this, that they can exclude the company, even if it's an EU company, formally speaking, if it's given subsidies by a foreign. So it's not attacking subsidies given by, say, Colombia in Colombia, or Guatemala in Guatemala, or Nigeria in Nigeria, right? It's attacking subsidies given inside the EU, because Guatemala or Nigeria may be exploring or exploiting this distinction between public and private entities in order to acquire control over certain technologies or markets. And second, it's challenging also the interstate nature of the market, and that was done by this new countervailing duties on Egypt. So the countervailing duties were against Egyptian produced glass fiber fabrics, but the subsidy was being given by allegedly Chinese public bodies. So there is this China-Egypt Suez Economic and Trade Cooperation Zone, where Chinese companies installed themselves in Egypt and received what the EU believed were subsidies from their which you can also call capital, right? But that the EU understood or found came from the Chinese government, and that would go into the EU, not from China, but from Egypt. And then the EU and the Court of Justice of the EU just approved that a couple months ago. This said this was lawful and in line with the subsidies agreement as well. And they interpreted the subsidies agreement in such a way that the subsidies can be given by a member. So you can see that in these two unilateral measures, the kind of things that a new subsidies regulation that would be found workable by countries that are trying to protect their own market and their own capital from unfair foreign competition would want to see in the new regulation. Thank you.
So just as with the first round of questions you took away, there's a number of long-standing issues. In the second round, you've taken away, despite the fact that there's been limited multilateral progress on new rules, there's still a lot of innovation that's happening, right? Innovation happening through RTAs, innovation that's happening through unilateral regulations, innovations that are happening in the types of industrial policies that countries are undertaking and so forth. So before I open it up to questions from the floor, one final question to all of you. Since the title of this panel is Reimagining Subsidies Control, I just want to ask you if we could erase all the rules today and we gave you a magic pen to rewrite the rules, what would your rules say? Anyone want to start?
You're finishing up with the easy question, right?
This is way beyond my PhD right now. So.
But hopefully this is sparking, right, the reimagination on the part of everyone else here, and give a chance, right? What better, especially for those of you who are just completing your PhDs, what better chance to have, right, some of the top experts in the field engage with your ideas here. So just it may be a tough question, but it's really an opportunity here, right? So
the name drop heard around the world.
Well, if I may start, I think that's a great question, maybe for someone to do a PhD on. For me, I think maybe like if not a rewrite, maybe like for states to think of how to not only rewriting or writing new rules, but maybe really look at what we have, as I stated earlier. I think maybe we have too many rules, like to catch up, like regional trade agreements or other agreements. So maybe, yeah.
Fewer rules and more flexibility.
Maybe fewer rules, and look and really think hard of how can we do with the existing rules.
And any principles for the guardrails? What can't you do?
You mean
in terms of subsidies? Yeah.
In terms of subsidies, well, my thesis is not on subsidies, so maybe I could tune in on SOEs and public
maybe just public body.
Public
if there was no ruling on public bodies today, you were writing the jurisprudence of public bodies.
Well, I think, okay, let's assume that there is no ruling. I think there are rules we can look at, for example, the ILC draft articles on state responsibilities, and there are so many cases on sovereign immunity law, and which really like the decisions of how the domestic courts see the relationship between a state-owned enterprise and a state is so different from the trade law context. So for example, under the WTO, the US argument is that so long as the state has a majority ownership or even minority ownership with control, it should, such SOE should be treated as the part of the state. But under the law of sovereign immunity, if we do this, it means many SOEs, if not all SOEs, would be treated as part of the state, and that means they could attract immunity, which would disrupt commercial activities. So instead of writing more rules, maybe we can think about how we can converge those probably conflicting rules in a more coherent way.
Interesting idea, right? So if you assert that something is a public body, right, you're foregoing sovereign immunity and all 164 members, or 163, I should say, right? Not maybe even your own, right? Sovereign immunity exceptions there, right? So some consistency there. Others saying?
Okay, I can go.
You don't have to answer the question,
me-
but yeah.
To me, you see, the question was too hard, Mark. To me, a new subsidies agreement should be one that reflects, and I'm gonna use a bit the introduction that you made, Geraldo, is one that reflects this common understanding between all the members that there is a certain policy space available, and that an understanding that carves out some more policy space in the case of subsidization. I liked how you framed that. The agreements that are more like a deal, and the ones that are more pursuing a higher purpose. And I think for the subsidies agreement, at least, that's definitely warranted. And I would also imagine such common understanding or such common idea to be open-ended enough to be also future-proof, to not only be able to deal with the current pressing problems or those that we might see coming in the near future, but also hypothetical ones that in 25, 50, 75 years will be there, because our new agreement will be still be there in so many years.
And Peter, let me just follow up on your idea here a little bit. Would these be one set of rules that fit all sectors, or even more sectors, right? We have one set of rules for agriculture and one for everything else. But in your world, do you think, right, there would be one for agriculture and maybe one for renewable energies, maybe another one for, say, high-tech defense related, and so on and so forth, right? How do you think about structuring this?
It's an interesting question. Actually, it is true that there might be a need, or might be an advantage of having more sectoral orientation and having the opportunity to delve into the specificities of the problems or the specificities of a sector. So I'm now thinking if it would be an or an or story. Would it be possible to cover the entire economy with only sectoral agreements, or would you still, having those sectoral agreements, still need a general one? I would be tended more to have also a general agreement, a general subsidies agreement, complemented by sectoral ones.
So framework and then specific ones underneath.
You need some sort of catch-all, situation as well, right?
I'll pick on that. I don't know. I was thinking about the idea of carving out sectors, and perhaps we could go like on a step-by-step approach, not a case-by-case, but a step-by-step, both on sectors and like priorities, and also I would suggest on countries. I would think there would be possible, so some kind of agreement would be possible, some kind of convergence would be possible if we differentiate between countries that are taking these measures. So the countries that benefit the most from the multilateral system, such as the smaller ones, the poorer ones. I wouldn't say developing countries, because that's more of a complex scenario. I don't know if, for instance, Brazil, where I come from, or India, would fit in this possible convergence. But the smaller and poorer countries perhaps would have the more general exceptions that they could use subsidies or some kind of non-commercial assistance to address their immediate needs. And perhaps on a step-by-step basis, you would be carving out sectors, technological sectors, defense sectors, and also countries which pose a more significant geopolitical risks. I'm not talking about China or the EU. I'm talking about these medium, bigger countries such as Brazil and India. Maybe this proposal here does not benefit my own country, but perhaps we could go on this step by step, carving out countries and then sectors, and then building on more rigorous, or on a more negotiation basis as it becomes more geopolitical riskier.
So I would start with, again, object and purpose, maybe go back to that, right? So what is a trade agreement? And because you can see this in two ways. So the way trade agreements are negotiated and the way countries address them, especially when they're in a dispute, is that this is an adversarial situation, right? So country A gets something from country B gets something from country A, and that's the beginning and the end of it. But in fact, that's not how it works, right? So at the end of the day, there is an overriding purpose, and it only works because after the agreement you have a surplus compared to what you had before. So in a way, of course, not everybody is better off. There are winners and losers, etc. But there is a surplus that comes out of this. And where does the surplus come from? It comes from the fact that you're harnessing the forces of the market. And again, I'm quoting Adam Smith again, since it's the 300th anniversary. You're harnessing the force of the market to require people who are ultimately self-interested in order to attain their own self-interest, provide something for others rather than taking from them. And so that's the final goal of the system. And you have to think of is to what extent are these new measures that we're seeing and this action through public bodies, if you want, or companies or state influenced entities, are these wealth creating or just wealth diverting, right? Are these things just diverting wealth? Because there was this old idea that if China is subsidizing solar panels, it was just send them a thank you note. And then why is anyone annoyed by this? If they can make everyone else in the world buy cheaper solar panels and facilitate the green transition. And of course, the reason is that in doing that, they are diverting some of the world's income to themselves and ultimately some of the world's power. And then this brings me again to Theófilo, right, who was talking about conflicts of conception versus conflicts of interest. So as long as we are within the realm of conflict of interest, trade law can help us, because then you can have, at the end of the day, a mutually beneficial solution, again with winners and losers on both sides, but that's something that creates a positive delta. When you're thinking about conflicts of conception or the way of distribution of hard power and economic value being not a way of satisfying needs, but a way of accumulating power, and of course it's always both. But then it becomes very hard to think of a solution, and I think that's the quagmire we're in, right?
That's certainly the quagmire we're in, and I'm just going to deepen the quagmire one little bit before we open up to questions. We've just talked about subsidy rules for goods, but the world is changing where the blurring of the distinction between services and goods is happening, and we don't have, right, increasingly, we might be able to subsidize through subsidizing the services related to industrial goods or the digital data that's related to it and so on and so forth. So anything else you want to toss out to the crowd to think about as we imagine subsidies controls for subsidies outside of the goods domain?
I'd just suggest that you listen to Chad Baum's latest podcast, trade talks on industrial subsidies given by Romania by not charging income tax from software developers, and that it worked. So it works.
Yes. So going to services route is an indirect subsidy, right? So all right, so with that, I left more than half an hour, right? So lots of questions. What I'll do is I'll take two at a time, and then please identify yourself, and then we'll try to get everyone in, okay? So let me start in front here. Please keep your questions or comments short.
So thank you, Mark, for the excellent panel. So I'm actually, I have a good question.
James, would you mind introducing yourself? Just
My name is James Leddenberg from Center for Trade and Investment in New Delhi. So my question is actually with respect to the club approach. So if you have to really deal with a country like China, how will you actually bring it under the club approach?
Henry Gao from Singapore Management University. I have two questions. The first one is at the technical level. The new foreign subsidies regulation of the EU actually has an interesting new approach when it comes to subsidies, because when you look at the WTO SCM agreement, they focus on the effect on domestic industry, the domestic producers. But the new FSR actually, by focus on merger, for example, and acquisitions, and public procurement, you could argue that it shifted the focus now to the consumers, effect on consumers, and also the effect on public or the government finance. So I was wondering whether the panel thinks that this is an approach that should be brought to the WTO so as to expand the scope to not only just cover the effect on domestic industry, but also the wider range of stakeholders. Second question is broader. So the panel has not discussed this increasing subsidies risk among the major players, with not just China. I mean, previously everybody pointing the fingers at China, saying that you have been providing this massive subsidy, but now with the CHIPS Act, and also all these subsidies by the US and EU on subsidies. So do you think this would make it actually easier for everyone to agree? Because I mean, talking of the rewriting the rules or clean slate that Mark mentioned earlier. If everyone is equally sinful, wouldn't this make it easier for us to agree to finally to have a new accord of subsidies?
Great. So three questions here, right? One is, can you bring China under the club? If so, how? Second, changing effects test, good, bad thing, right? Third thing is, if everyone's sinner, does that make it easier for us to all find God?
So may I take on James' question? How do you bring China in the club? I might be overreaching here my own argument, but I don't think you bring China in the club, not as a direct effect of this club-based approach. I would say that you lay the rules that you want to lay, and you take the risk that China's going to accept that or not. But I don't know if you try to actually convince China to join this club. I would say that if China would to join either the TPP or any kind of rules on agreement with this kind of rules like this 70% of voting shares or 70% of shares to control, I would say it might bring some kind of hardships to China, but I wouldn't think that it would somehow disrupt the Chinese structure of SOEs or would somehow achieve the aims that these agreements are proposing themselves, because I do see China with a lot more complexity, and I would say that government has means of controlling these enterprises, either public or private, that do not necessarily go through these more Western-based means of control. For instance, those functioning of party cells within these enterprises, or regulatory obligations of sharing information, or some other forms of control. Like you could say that the borrowing from some kind of elite theory from Victor Xi's work on how China controlled inflation. You have a specific professional background from all of these managing directors that I don't know if these kind of regulations would somehow create problems to this kind of government control. But then again, to your question, I don't think you might as well try to bring China in the club. I don't know if that's going to make any effect, but I don't think you try to bring China in. You just take the risk that China might agree or not with the rules that you want, because what you want is to protect your own goods and your own industry. Yeah.
Thank you for your question. I think the first and the third question are related. I think regarding the first question, it reminds me of the formation of customary international law. It requires state practice and then opinion jurists. Any customer law, I think it comes from some states' state practice. I think, as you mentioned, if some states started to make rules, for example, CPTPP, China, I think, has submitted its interest to negotiate and to be part of it. I think that's probably a good sign. And I think if that can be a good platform for more negotiation or talk, I think maybe in the context of this increased subsidies race, when everybody's subsiding, maybe it's also a good platform to have those kind of discussion, whether there's going to be an outcome or not.
Well, do you want to take Henry's other question?
With the effect on consumers.
Yes,
Yeah.
the broader effects test.
Yeah, I wonder, it's because I feel that ultimately this takes us a bit back to the interstate aspect, right? So in the sense that I guess ultimately you're fighting for your consumers, but the foreign subsidies regulation seems to me to be a way to make sure that the European industry isn't competing. Let's say it's competing against Chinese industry specifically. I think that's even this one is particularly aimed at China, and not with the Chinese industry plus the Chinese government. I think that's the ultimately the point, right? And that's also, I guess, the issue with it brings us back to the equally sinful question, which is that if you see this as a purely interstate matter, then sure, everyone, well, of course, you're talking everyone who can actually, whose government has actually the money to subsidize. But the issue is that the question is whether the subsidies, the world of multiple or multilateral, or everybody's subsidizing, is this a world that is better in some way? Is there an actual object and purpose in the sense that is this neutral as a matter in terms of how well the system works, or is this going to make for more inefficient system? So if the subsidies are the kind of subsidy that is aimed at addressing negative externalities, then maybe we're better off if everybody's subsidizing their the electric cars and their solar panels. But if it's a matter of everybody's subsidizing their steel production, then you're going to have overproduction, inefficiency, and a lot of ultimately trade wars, right? So the reason we have an agreement, or the reason members get to an agreement, is not because not only because they have a common objective, but because they want to avoid the alternative, which is interacting on the basis of ever greater cheating and self-preferential measures that are ultimately self-defeating for everybody.
I'll take two more questions. So maybe let's go over here first, so to two over here. So,
Lauren Bartels from Cambridge. So 2 points and questions really on the foreign subsidies regulation. Well, actually, to Henry, I'm not sure that that's about consumers. It's about national security, essentially, element of Chinese buying up everything. That, of course, is now extended to China. They've got plenty of tools in the EU to, competition or decades already. But I think one of the beautiful things about the foreign subsidies regulation, by the way, I don't think it's the subsidies paid to cover subsidies paid at home as well. Exactly the point, and this gets to what Peter was saying. It's a fantastic transparency tool. In fact, sometimes I wonder whether the whole thing is just dressed up transparency tool in the guise of being worried about Chinese takeover of the industry, because all companies do serious business in the EU are busy filling in at great cost forms telling the European Commission that all the subsidies that they receive. In other words, you don't have to worry about the government notifying the WTO. The Commission's done very clever. It's got all the companies to do for them.
You mentioned sovereign immunity. Don't forget the commercial activities. Creating new rules needs to challenge it. Achieving agreement, getting it right. Much easier. But much easier to work with existing rules and interpret them correctly, and that can mean rolling back developments that have gone in the wrong direction. So on SOEs, these matters of attribution, those rules matter when you just have a rule that applies to a state and nothing more. As soon as you have additional wording, whereby state enterprise, Article 17, obviously, what is a state enterprise, state owned, state controlled, or a public body, then you're not in the realm of attribution. That's why the authority doesn't matter. That matters for attribution. But here you just have to have authority for a state enterprise. And another thing where I wonder whether things have gone off in the wrong direction is the actionable subsidy. Very important. That's the most important part of the subsidies agreement, because it's all markets, home market, world market, contracted market, and destination market. The threshold for demonstrating serious prejudice. Indonesia cars seemed still manageable. Then came the aircraft, the Brazilian aircraft case. And then at some point, the Airbus Boeing, hasn't this gone completely out of, if you consider that a subsidy that is not decoupled and, or keeping somebody in business, otherwise not really those subsidies really distort trade. So you must be possible to demonstrate serious prejudice a little bit more simply in practice.
And Lothar, can you introduce yourself?
Yes, and I'm Lothar here in Europe.
All right, so 2 comments, FSR and actionable subsidies.
It's interesting indeed to pull the transparency angle to it, because but it's not really transparency, right? It's just a lot of information for the commission. It's not very public to everybody, but that's indeed a very interesting remark, and thank you for that.
Well, thank you for your question. So, or your comment. So, I just want to make sure I understand your comment. You're saying like the current rules need more revision or new rules to be made because of the injuries from that
No, the point
perspective.
is just new rules would be great, but we know the challenge. Sometimes that works, especially look at how long it took. And so let's also focus on the existing rules and use them well and correctly. And maybe that has not always been done so far.
I think,
and I mentioned a couple of possible examples.
right. I think on attribution, I think on your part about public bodies of, to what extent state-owned enterprises or enterprises, even not state-owned, whether they can carry out those activities. I think like whether even if there is no definition of SOE, let's say, I think when we look at the hard work that has been done by the International Law Commission on state responsibility, I think there are 3 articles. One talked about the government agency, but I think there are other talked about, even though they're private entity, if they were under the instruction of the state, they can be attributed to the state in some circumstances. I think those are very important rules that we can look instead of think, oh, how do we define SOEs or not other entities?
Okay. So over here.
So Jennifer Hillman from Georgetown Law. So a lot of your discussion is really focused on this issue of how do we figure out whether something is definitionally a subsidy, and if so, whether it fits in the prohibited box or in some other box. I mean, just sort of generally, how do we want to think about it? I'm wanting to shift the conversation to, in essence, why does that matter, to go to the issue of remedies? I mean, sort of then what comes if something either is or isn't in the box, and whether you think that's been to some degree part of the problem. If you think about, for example, in the environmental realm, you've seen a significant number of countervailing duty actions on solar, on wind, on renewable energy. You've seen 0 on fossil fuels. Why? You sort of ask this question, and part of that is, who's got the incentive to file a countervailing duty case? And guess what? It's not multinational oil corporations. You go over, to the remedies on the actionable subsidy side, and what you see is a huge problem with the timing. The subsidy gets granted, then the facility gets built, then the goods get moved out into the market, then they cause market displacement, then you file a case, then you get a remedy, and time from the time at which the subsidy was granted to the time in which that ruling comes down, 5 to 10 years. Too late to have any significant impact on the giving of the subsidy in the first instance. I guess I'm just curious whether you think some of the problem is on the remedy side, and if so, what's the thinking about how to fix that?
Thank you, ma'am. Pieter from Cambridge University. Beginning a bit on what you said, Geraldo. You mentioned the rights of implementation and the fact that essentially it's filling the void because the SIEL agreement is just the production of goods, right? And now we have subsidies for services and for investment. And I was wondering if you reminded me of what led to the conclusion of the subsidy code and the SIEL agreement. we had more and more subsidies given for the production of goods, and then unilateral measures imposed by the US essentially. And then the parties go to the table and were like, okay, I'm going to limit the subsidies I give, and I'm going to limit the unilateral measures I impose. And here, aren't we in a sense starting to see the same development? We see China giving investment subsidies, cross-border services subsidies, and then the EU responding. So could we use this momentum to maybe bring the parties to the table and say, okay, China, you will accept some discipline of your investment subsidies, and then the EU maybe even push some, you'll accept some limitation in your unilateral measures.
Okay, so two questions. One, right, are remedies part of the problem, or inadequate lack of remedies part of the problem? So how we can fix that? Second, could FSR, especially broaden the scope of what can be targeted, serve in some of the ways, like the U.S. actions that triggered the Tokyo round and the codes, and then eventually the Uruguay round agreements?
Professor Hillman, your comment, of course, is 100% spot on. It's definitely problematic. The timing for whole, let's say, the whole lifetime of a subsidy being given, good being made, and then until we come to both the finalization of an investigation for a countervailing duty, as well as finalization of a dispute. And maybe one, definitely in our reimagining subsidies, or our new agreement that we're writing on subsidies, remedies must be a very important part. Whether I have specific suggestions to add on besides the two main avenues that we have right now, I don't know at this stage, to be honest. But what I can maybe add is that there are a couple of proposals and a couple of potential ways of how to limit the imposition of countervailing duties on those goods that are considered environmental goods, or that could be considered goods that we would like to shelter extra from anti-subsidy action. There's a lot of conceptual problems ahead of that, because it would require an agreement of some sorts on what list or what criteria for an environmental good, or what exact type of goods that we would shelter, and as well as I'm talking more within the current within the framework of the current rules, what kind of halts we could put on the imposition of countervailing duties. There have been several proposals, like a shorter time frame of imposing. If you just limit the imposition of your countervailing duties from 5 to 3 years, it would, after those 3 years, if we're working with the hypothesis that it's not prolonged time and time again, would protect for a shorter time. Restrictions of the number of trade remedies that could be at the same time imposed, mandatory considerations of the environmental aspects of the goods, also mandatory application of the lesser duty rule in case of environmental goods, etc. So there are these proposals, and as such, some of them, or any and all of them, have their value. It does ask a lot from the states and from the investigating authority to be willing to restrict themselves, imposing or limiting themselves, exercising their powers for the greater good. So I'm not that sure that many investigating authorities would be from the goodness of their heart thinking about other aspects than their industry. But I figured I wanted to add that to your question.
Maybe a compliment what Peter said. Yeah. So on this point of the remedies, thinking a lot here. Yeah, I do agree that remedies are part of the problem, but I would ask what's the aim here with those remedies? So what's the end goal? Because to take what Geraldo has said, remedies are a problem if you are trying to tackle some kind of inefficient allocation of resources between countries. Then you have a good or a service that could be provided more efficiently in the United States, and because of subsidies in some kind of developing country, you have this inefficient allocation of these goods and of this wealth. But when we're talking about these new fields such as environment or this high technology, this frontier of the technology, or some kind of this sort of new fields that are now arising, which are most of the core of the discussion, I don't believe that there is yet like a conclusion on where those goods or those services are provided more efficiently. It's more about a question of which country is able to provide this kind of good and this kind of services. So it's not, I don't think it's the same rationale here. You're not talking about inefficient allocation of resources. You're trying to decide where it's more efficient to provide those goods and those services. So it's a different question, and I would say that the question of remedies is also could be seen differently depending on what kind of good and service you're talking about.
So I think the two questions are related strangely in my head. So for the remedies, and of course you know this, but just to rehearse, so we've had attempts, right, at providing more than prospective remedies. So the WTO is seen by members as a way to manage their relations prospectively rather than providing redress retrospectively. So you've had during the time of the GATT, Norway, Trondheim, Ring, where the US was complaining about the government procurement, but that was exactly the same situation. So let's say they got the US won, and there was a procurement given to a Norwegian company, but then what do you do about this, right? The contract was given. The panel decided not to determine that the contract had to be reviewed, but that could have been different. Then you had Australia automotive letter 2, again, the US, bringing this case against a subsidy given by Australia to automotive leather, so the thing that goes on the seats of cars. And then the US won again, but then the panel couldn't, then the panel actually, one of the panels, the compliance panel, tried to say that, and actually said, because it was adopted, right, that the panel report was that Australia would have to withdraw to remove the subsidies and demand the repayment. But members were very angry at this when this report was adopted. So there is some attempt, and I have an article on this, so that's why I know the case law. So the attempt, and I don't remember the name of the case. In this case, it's China is the respondent, where it was a success. Yearly measures that China was giving that said, well, that China has to redress the situation in a way that the successive measures don't mean the continuation of the same violation. But that's as far as it goes, right? Which is not sufficient for what you're talking about. You're not talking about consistently given subsidies, but subsidies given once. And then, so this put me, let's say, I'll try not to connect it, but I think the answer is, how do we rearrange this and solve this without making this essentially what the EU laws are, right, in this regard? So yes, the company has to repay in the EU law, and now you have the whole investment law question, how does this interact? But the company has to repay the subsidies. And that's fine, but it would require then really rewriting the rules of the whole system. And I wonder if members are willing, I mean, hopefully one day, but it would mean, what a mini world government, right? That's, which tends not to be mini, as the European Union institutions show us. And then this sort of brings me to Victor's question, I guess, which is that, again, the EU, the WTO law is a way for states that remain, in the case of the EU, of course, organization, that remain independent to manage their relations other than by punching each other in the nose repeatedly, right? So they have an agreement, they go to a panel, they could, because I mean, you have this idea that the WTO gives members the right to retaliate, but of course that's not true. The basic situation under international law is that you can retaliate, you just adopt the countermeasures. If there were no WTO, it would be much easier to retaliate than with the WTO. And then there is the issue there, and I think that's, let's say, at least that's one reading of the situation, is I think what the international relations scholars, as far as I know, it's called evolutionary game theory. So the idea that, you have the basic prisoner's dilemma situation where parties are not cooperating and it's bad for all of them, so they start cooperating. The problem is that if everybody is cooperating, then the incentives to cheat are very large. And so if you're the only one cheating, of course, that's great for you. And that's what let's say the accusation, and I mean, Mark can speak about his own article here, is that China has created this legal operation that, whether intentionally or not, games the system, in that they can, while, let's say, objectively abiding by all the rules, continue to divert trade and divert economic production to themselves. And so you would need, let's say, and then if that is actually what's happening, then if one of the participants is undermining through surreptitious means the arrangement, then sort of the international relations response, that's not my proposal, is that the way to fix that is to go back to punching each other in the nose a bit. And that's what we're seeing right now.
Right, so we have about a little over 5 minutes left. Let me collect the round of additional comments and questions, and then I'll just invite. So I see 4, so it's 1, 2, 3, 4, 5. Okay, so.
Thank you. Alicia Angón, professor and trade lab tutor at the Universidad de los Andes and associate at Curtis. So almost all the debate is around the misuse or overuse of subsidies and revenue countervailing duties. But the key issue for me, I'm from Colombia, is about the underuse of remedies. Why? Because I think we can all agree that for the multilateral system to work, we need to all benefit, have the capacity to benefit from the multilateral system, but also to defend against disruptions and distortions of international trade. But for Colombia, we have only initiated in our history one subsidies investigation and have only once imposed countervailing duties. And I was formerly a government official, and when talking with the productive sector, what they've said was we need to get out of this system because it's not rendering good results, and we're being affected by subsidized products, for instance, from the United States, corn, and so forth. But there was no awareness about the existence of these tools, very powerful tools of the multilateral system to defend against. But the only solution was the increase of protectionism here in the non-active users of trade remedies. So what about the non-active users of trade remedies? How can we be empowered to use these remedies as a way to avoid the surge of protectionism and leaving the system as the only way out?
I just wanted to at the end offer a comment that I think the problems are much deeper. The SIEM agreement was negotiated at the high days of neoliberalism. We strengthened the rules. If you look at the role of the government in the economy today, that has completely changed. And if we look at the challenges we face in climate change, and we still have to operate with these rules, it's perfectly understandable that the big powers don't want to submit to binding arbitration and dispute settlement because these rules don't fit. Just take the example of a traffic light approach. We have a series of facts which could actually provide space, but paradoxically, developing countries then insisted it should be removed because they don't have the funds to use them. But should we revive the traffic light approach? And then what about export subsidies? We have a complete ban. How do you want to fund technology dissemination with such rules? So I think you really have to go back to the ideology under which the stuff was negotiated and ask what are the economic theoretical conditions under which we operate today, and then start to go back to the drawing board in reactive reimagining subsidy controls here.
I'm just wondering if there's any reaction to a possible idea that perhaps we contemplate expanded use of notifications. So, for example, subsidies, notification by countries of other countries, subsidies. And I'm just wondering if the solution I find that they think others just to take some of this information that seems to be wash out there about subsidies and be able to bring it forward and proceed there with
So if you want the SIEL rules as they are kind of a simple engine. We have Article 3, which has these export and global content subsidies that are clearly banned. Maybe if the WTO could do those faster, like, how about that? Maybe it could deliver a meaningful, a remedy on a commercially meaningful timetable. Maybe. It is enough. But of course, the question is, global content subsidies were, there are stories behind about how those happened a year ago around. I'm not sure they're a great idea as a rule. And they, as Thomas has said, maybe maybe we can do about those in the 21st industrial policy century. But what else is there? There's these yellow light rules that have only been used on head-to-head competition. Fantastically expensive cases on cotton and aircraft. Now, it would be possible to revive the dark amber subsidies. That was actually a bright line. Don't subsidize too much and whammo, you're wrong, you're a sinner. There's an idea. And maybe that's what Lotar's suggestion was. As for countervailing duties, US has been doing countervailing duties, I mean, really high ones, on a whole range of Chinese products. You have a reaction, and the US, I think, has been doing countervailing duties as well. And the question is, this may be a remedy for the domestic industry, but is this actually changing Chinese government behavior?
Okay, so we've got a range. I'll just invite the panelists to take any of the comments, questions that you'd like. Maybe Geraldo, I'll start with you, just work our way down.
Yeah, so under use of remedies, and I think this is point by Jennifer, the under use of remedies also when fossil fuels are given, for example, but also it's tricky because of course normally you can see trade remedies and as this sort of rebalancing tool, right? Or just as a sort of escape valve form of allowing countries like a bit of protectionism when they want. So in that sense, like the Colombian approach is not that different from a lot of the wizardry that goes behind trade remedies and calculations and all that. So I suspect, and then on the climate change situation, and that's something that of course Thomas Gauthier also brought up. It is because I let's say if you wanted to say, what is the solution? Of course, the solution would have to be to have a global body that can see everything and can make decisions that we hope are virtuous regarding which subsidies are allowed and which aren't. But it's very hard because, of course, if we do have a plurality of centers for decision making, and each of them has a bit more interest in their own well-being than in the others,
I wouldn't know how to fix this without instituting a sort of global version of the European Commission, just deciding what is, what is it, and have rules on what are good subsidies, and someone to decide, okay, if this is green enough, it can go. If it's not green, even if it would otherwise be allowed, say, in the sense that it's fossil fuel subsidies, the reason that they're not targeted, of course, is because they're normally consumer subsidies, and of course, you know the answer. And therefore, look what happened also in France, right, when they decided to end to increase the price of oil or of gas for a bit. So it's the famous, and I think I'll stop here. You have to change a tire with the car moving, right? So it's not going to be easy.
Yeah, so I think what Professor said is just I completely agree with it, and it's actually interesting that when we talk about technological dissemination, we're not necessarily talking about protecting domestic industry, but actually achieving some kind of benefit to consumers or citizens on all around the world, and actually to smaller and poorer countries then that could also benefit to this kind of dissemination, and it wouldn't be possible without some kind of subsidy. Or incentive. So yeah, maybe we are talking about a kind of economic ideology that does not provide the same kind of solutions and the same kind of benefits that we used to. And because of Colombia, I thought very interesting because yeah, the state, even under this previous economic ideology, the state should have the capacity to retaliate and should have the capacity to afford to retaliate, right? So it's not only a matter of knowledge of which tools are available, but I mean, if you're retaliating on this, what protects you against any kind of unilateral retaliation on other sectors that are more on which we're more dependable, which were a smaller country. So yeah, it is there is a necessity of rethinking the ideological foundations.
I think based on the theme of the conference, I'll just make a general comment. I think for any new rules to form, I think it's in a way it's political. I think in today's situation, I think agreement firstly probably has to, or talks have to be initiated between the US, the EU, and China. I think before anything can happen between them, maybe we still need to look or think about how we can use what we have, the rules we have.
Peter, you get the last words.
Starting and finishing, okay. On the use of remedies and how basically trade remedies or the knowledge of the knowledge about the fact that there are avenues of relief for local industry. I guess it's the task of the government to inform the industry. I know that not very specific, but that in the European Union, it's always one of the action points of the European Commission to spread the word about the fact that it is possible and it exists. An alternative would be to have a set of overly active lawyers that are actively spreading the word of their service to help the industry. But that's how, I guess that's how it goes, and that's how it works, and we build upon each other. I have mentioned now in private practice that it's often closely related industries or upstream, downstream industries that see from their neighbors basically, oh, you have this solution, maybe we should investigate whether that would be available for us as well. So go out and spread the word, I guess.
Questions?
Yes.
On fish.
Exactly. First, the counter notifications. Counter notifications, indeed, I think that was one of the pressure points of several countries, and especially the United States, to actually bring those counter notifications. But as far as I know, besides a mandatory mini discussion, that's also where it ends. I don't know if a lot of these, maybe only if a huge surge of counter notifications comes, if we use all the information from the Commission, and the Commission brings it to the table in the WTO, maybe on a massive volume, it could create some momentum and some force to discuss and could force certain WTO members to discuss. But well, the instrument of counter notifications for the rest, to my understanding, doesn't have any teeth to bring a lot of relief. And then finally, on the fishery subsidies agreement, I couldn't understand you very well, but I think the gist of your question was how exactly would it be, how exactly could the fishery subsidies agreement now be reproduced or be used for other fields such as fossil fuels? I don't know. I'm not in the I'm not in the hallways in Geneva. I'm not in the negotiations in Geneva. From what I recall is that at least there is already some understanding amongst a club of not an insignificant number of WTO members that fossil fuels shall be phased out and ultimately be prohibited. So I guess it would just follow the same route of a prohibited subsidy. This angle of how to phase them out would be interesting to see. And I think.
All right, so I hope we've given you a lot of food for thought about how to reimagine subsidies control. Please join me in thanking our panelists.